If you're unhappy with the treatment that you've received, you may wish to obtain your medical records. If it's for yourself, you can do that under the Data Protection Act 1998. A parent or guardian can also do it for a child under 16, but a child over 16 can actually give consent themselves. It's slightly different if it's for a deceased person, because that would be made under the Access to Health Records Act 1990, and that would be usually made by either the executor or the personal representative of the estate. There are only very limited circumstances that a request for medical records could be refused, and that is if it could cause mental or physical harm to a person, or it would identify a third party. In that circumstance, then that information would usually just be removed and they'd be sent to you then. A GP will keep your records for 8 years after any treatment that you've received, and a hospital trust will keep them for over 10 years. You're actually only entitled to records, your medical records, after 1991, but usually a trust will send you the entire set. It usually takes about 40 working days to obtain your medical records. It can be a little bit longer, so don't be disheartened if it takes a bit more time. It costs £50 per set of records that you'd like to apply if it's for yourself or a living person. If it's for a deceased person, then it's £10, but then you actually have to pay the cost of someone actually getting the records and copying them. If you've already obtained your medical records and you think you've been a victim of medical negligence, you can send those records through to us and we can review them. If you haven't obtained them, we can actually make that application on your behalf if we think that you've got a successful case.